All right, good afternoon. On behalf of the Federalist Society Lawyers Chapters of South Carolina, happy to welcome all of you who are joining us virtually. Delighted as well to host our panelists today, Professor Volokh and Casey Mattox, who will introduce both of them a bit more fully in a moment. I see our numbers are ticking up. I'm going to make a few housekeeping announcements at the beginning. That'll allow stragglers a moment or two to join. First off, I suppose I should introduce myself. I'm Miles Coleman, partner at Nelson Mullins, and the chair of the Columbia, South Carolina chapter of the Lawyers Division. As I'm sure all of you know, we've applied for CLE credit in South Carolina. In order to get the credit, the Commission on CLE wants all attendees. We need a way of checking in to make sure you're still with us and paying attention. So we are at our first checkpoint for CLE credit. If you go down to the bottom of your screen, you'll see the Q&A function, not the chat, but the Q&A. If you pop that open, if you would, please just send a Q&A that'll be visible just to me that has your name and your South Carolina bar number. I'll remind you about halfway through the program to do that again, and then once at the end of the program. If you are also barred in North Carolina or working on getting CLE credit in North Carolina, shoot me an email and I'll make sure to keep you apprised of the progress on that. Lastly, for CLE, if you're on the phone with us and you can't use the Q&A, you can send me an email at the appropriate times to record your attendance. It's miles.coleman@nelsonmullins.com. All right, well, enough of that. Nobody wants to hear endless announcements about CLE credits. Let's get down to the more interesting matter at hand. As I said a minute ago, we're pleased to have two distinguished panelists with us today, who I will introduce briefly, and I suppose we'll go in alphabetical order. Casey Mattox is Vice President for Legal and Judicial Strategy at Americans for Prosperity, where he advocates for a legal system that respects the rule of law and protects individual liberties. Prior to that, he spent 15 years as a First Amendment litigator in a variety of states and federal courts. He is a proud product of the Alabama public school system and served as the president of the Alabama state chapter of the Future Farmers of America in 1992 to 1993. He went on to earn an undergraduate degree from the University of Virginia and a law degree from Boston College. Our next speaker, Professor Eugene Volokh, teaches First Amendment law at UCLA School of Law. He graduated with his undergraduate degree from UCLA at age 15 in mathematics and computer science. Spent a bit over a decade working as a computer programmer before going to law school, again at UCLA, where he graduated first in his class and went on to clerk for Judge Kaczynski on the Ninth Circuit and Justice O'Connor at the Supreme Court. He's been on the faculty at UCLA since 1994 and has written more books and articles than we can count, all of which have been cited in Supreme Court opinions, other law review articles, and by many other distinguished sources. Our topic today, let me just kind of tee it up briefly, and then Professor Volokh, I'll let you take the lead, but just to give folks a bit of a background of how we have gotten to the topic for today and what we'll be doing with our time together. Back in, I believe it was around 2017 or so, the ABA, the American Bar Association, reached out to, I believe, all of the state's Supreme Courts to request they consider a new proposed model rule, namely ABA Rule 8.4. In South Carolina, at least, the Supreme Court opened a comment period and received extensive public commentary, both in favor of and opposed to the proposed rule. The South Carolina Attorney General issued an opinion warning of potential First Amendment deficiencies of the proposed rule. In 2017, the Supreme Court ended up declining to adopt the rule. At some point this past year, probably in the last 6 to 8 months, the idea has come up again in South Carolina, and the South Carolina Bar's Professional Responsibility Committee has taken it under consideration. I should mention too, we had invited the past chair of the Professional Responsibility Committee to join us as a panelist today. She was deeply involved in this proposed revision of Rule 8.4, but unfortunately schedules did not align. But in any event, the Professional Responsibility Committee has produced a revised version of 18.4, which passed out of committee by a vote, I believe, of 18 to 11. And it's currently under consideration by the House of Delegates, which is the governing body of the South Carolina Bar, and they may or may not recommend it to the South Carolina Supreme Court for consideration. So it's very much a live topic, though one that we have looked at before in this state, and one that I know Casey and Eugene have looked at and written and commented on extensively. So I'll turn it over to Professor Volokh. For those of you watching, I'm sure you'll have questions. You can also use the Q&A function, and once we've given Professor Volokh and Casey a chance to kind of make their opening presentations and remarks, we'll have some Q&A at the end. So be thinking of questions, send those in, and that's enough for me. I've already burned like 6 minutes, and nobody wanted to hear from me for that long, so I'll turn it over to Professor Volokh.
Thanks so much. Very much appreciate the invitation. It's an interesting and important topic. Let me see if I can share the screen. And here's the thing. Oh, host disabled participant screen sharing. Can you allow me to share the screen, please?
Well.
Sorry, I should have tested that here.
Here we go. This is my first time actually as the technical host, and I'm proud to say that I believe I've now enabled it.
Okay. All right, so let's start at the beginning. Do you see proposed SC 8.4H at the top? All right, technology. All right, so this is going to be a busy slide with lots of text in a small font, but that's part of the important point, that this is a complicated rule, has a lot of moving parts. It is a somewhat narrowed version of the proposed ABA rule. It is better in certain respects. But I still think it poses important constitutional problems. And then I'll also flag a couple of other non-constitutional but still potentially practical problems. So under the rule will be professional misconduct, so which could lead to discipline, up to and including disbarment. For a lawyer to engage in conduct that the lawyer knows or reasonably should know is discrimination, which is defined as unjust or prejudicial treatment. We're going to get to that towards the end. How do we know what's unjust or prejudicial, at least as to some of these categories? Or harassment based on race, sex, religion, national origin, disability, age, sexual orientation, gender identity, or socioeconomic status that either violates a existing federal, state, or local rule. So that would make into a disciplinary offense something that is currently a matter for civil litigation. Or even if there's no violation of a local rule or of a federal, state, or local rule, reflects adversely on the lawyer's fitness as a lawyer based on the totality of the circumstances, including whether the conduct was committed in connection with the lawyer's professional activities. So it isn't limited to speech within the context of the lawyer's professional activities. That it seems to be mostly aimed at that, but that's just one of the circumstances to consider. Now, what is harassment? Now, harassment has many meanings in our legal system. Sometimes it means like telephone harassment, calling someone up on the phone to say offensive things or saying nothing at all. That's not it. Sometimes it means what's sometimes called quid pro quo harassment, sexual extortion, sleep with me or I'll fire you. That's not it. This is closest to what is sometimes called hostile work environment harassment. And the rule actually specifically says that the law of harassment is supposed to influence the interpretation of this, although not binding on it. But it goes beyond the workplace, right? The whole point of this is to add extra rules beyond what is already prohibited by hostile work environment harassment law. So what is it? It's a pattern of intentional, substantial, and unreasonable intrusion into the private or professional life of a targeted person or group that serves no legitimate purpose and would cause a reasonable person or group member to suffer mental or emotional distress, and may include harmful verbal or physical conduct. Verbal conduct just means speech that manifests bias or prejudice toward others. So note, this is something that has some attempts to narrow it. It requires a pattern. It requires that it serve no legitimate purpose, but it's potentially quite broad. It applies to speech. It applies to speech because of its viewpoint. It's speech that manifests bias or prejudice that's being targeted. And note how vague it is. What is unreasonable intrusion into the professional life of a targeted person, or much less a targeted group? Those are not well-defined legal terms, at least severe or pervasive enough to create a hostile environment, vague as those terms are, there's at least a large body of case law from the hostile work environment context explicating those. But unreasonable intrusion into the professional life of a group, that's really hard to tell. And likewise, what is a legitimate purpose? So let's just give an example. Let's say somebody decides that they are upset by some religious group. It could be extremist jihadist Muslims, or it could be conservative Christians, or it could be the Catholic Church, or it could be Scientologists, let's say. And then let's say they start picketing outside of a house of worship. Maybe kind of rude in some respects. Some people think that shouldn't be done at all, but others say, well, if this house of worship is spreading bad ideas, we should be out here talking about that. Well, is that a pattern of unreasonable intrusion into the private life of a targeted group, being that religious group? Would it cause people to suffer mental distress? It does involve verbal conduct that manifests bias towards others. People are saying, this religion is a bad religion, spreads bad ideas. It could be a fraud, let's say. Many people say that about Scientology. And does it serve a legitimate purpose? Well, one might say yes, of course, because it's a legitimate purpose to express views, including biased views. It's a constitutionally protected purpose. But the whole premise of the rule is, at least in some situations, expressing biased views is not legitimate. How do we know what's legitimate, what's not? Well, then they try to elaborate a little bit more. So first they say the substantive law of anti-harassment statutes and case law may guide this analysis, but again, it can only take us so far because a lot of these terms aren't defined in that case law. Declining representation and advocacy of policy positions or changes in the law are not regulated by this paragraph. Okay, well, that's good. That's something, at least, although note this example of public protests about a particular group might not be advocacy of policy positions or changes in the law. They may just be advocacy that the public should reject this group. Nothing in this paragraph limits a lawyer's ability to advocate fully and zealously on behalf of a client unless such advocacy is not relevant to any legal or factual issue in dispute. So that's a narrowing principle, although again, note, suggests that if you bring in some irrelevant material, not only will it be, say, struck from the record, an objection will be sustained, you could be disciplined for that. That could have a significant chilling effect on legal practice. Then it says the paragraph does not limit the ability of lawyers to engage in constitutionally protected activities, including expressing opinions about controversial and or political topics. So that gets us to this example I gave. Well, maybe that immunizes the lawyer who engages in or perhaps helps orchestrate this protesting outside of the Scientology group or outside of, let's say, a Catholic church protesting against Catholics, the church's perceived failure to rein in sexually abusing priests or whatever else. Okay, that looks like it's exempted. But then note the proviso. However, a lawyer cannot invoke the constitutional right of free speech to immunize the lawyer from even-handed discipline for proven unethical conduct. So which is it? Is there an exception for constitutionally protected speech from this prohibition on supposedly unethical conduct? Or is there an exception to that exception on the theory, well, if it's proven unethical conduct, then you don't get to claim your constitutional right of free speech. So one hand gives, the other takes away. Professional activities, moreover, encompass a variety of things. Now, the first two are actually traditionally subject in many ways to court supervision. So for example, the second is the clearest example. If you're interacting with other lawyers in court or out of court, you could be potentially disciplined for uncivil conduct on the theory that it's prejudicial to the administration of justice. That if you insult those people in the course of your interactions, it makes it harder to work out compromises, whether settlements or compromises about how the trial is to operate. Likewise, if you badger witnesses in offensive ways, okay. But then attendance or participation in continuing legal education programs. So if you're in a debate at a CLE program on some question, for example, whether there ought to be bans on discrimination based on gender identity, whether, for example, male to female transgender athletes should not be allowed to compete in women's sports. Would that be seen as a pattern of unreasonable intrusion into the professional life of a targeted group that serves no legitimate purpose? Well, again, I think it serves the legitimate purpose of presenting an important position in a debate. But obviously, as we see in public discourse, lots of people think certain kinds of views that they label as hate speech or label as discriminatory or label as verbal violence don't serve a legitimate purpose. Generally speaking, it's not for courts or for disciplinary agencies to decide whether my speech and my advocacy is legitimate or not. All right. Now, a lot, though, has to do with harassment and how it's been generally understood. Again, we get back to item 7, anti-harassment case law. I'm sure that since this is going to be administered by lawyers within the legal system and the lawyer discipline system, they're going to look to case law, even if it's not completely on point. And they're going to look to it when it's in the CLE programs, when it's in, say, operating or managing a law firm, that would be most on point. And remember the item 2 near the very top of the slide, even this could apply even to things outside the lawyer's professional activities. That's just one factor to consider, but they'll probably try to look at the case law by way of analogy as well. So let me give you a few examples. They're not necessarily representative examples. They are kind of the broadest restrictions of speech that I've seen under the rubric of harassment law. Some of the restrictions are going to be on things like threats of violence or face-to-face insults that might already be punishable fighting words. Fair enough. Those there may be a good basis for punishing in various ways. But we want to see what the possible scope of this is, not just in the narrowest possible interpretation, but the broadest plausible interpretation that we've seen evidence that courts or administrative agencies follow. So here's an example: people wearing Confederate flag T-shirts. The EEOC, Equal Employment Opportunity Commission, said that could be actionable harassment. Here's another case from the EEOC. Complainant emailed the supervisor, complainant who was Jewish, emailed the supervisor that government employees generally work shorter hours than private sector employees, and she was working like a civilian. The supervisor responded, "Wow, then I must be a damn fool, because I've been working like a Hebrew slave the last 9 years and don't have enough time to take off. At least somebody got it right." All right. So you might ask, okay, what's wrong with that? Presumably, some of you know there's a Bible story about this. It's the story of the Jews in Egypt and Moses. Good story, has a happy ending. And even I, I'm a very bad Jewish boy. I never went to Hebrew school, but even I know this story. Well, the EEOC says, however, that the plaintiff, as a Jew, could be quite offended by, first of all, the reference to Hebrew, which is archaic and often used as offensive, which it is. If somebody calls me a Hebrew, I'd say, that's kind of odd. And I thought that was like 100 years ago people used to use that. It used to be a perfectly normal term, but it's archaic enough that it makes people wonder. And likewise, if people say that I, as a Hebrew, should be a slave, that would be pretty offensive. In context, this strikes me as not offensive at all, but the EEOC says this is actionable harassment. Statement that the Trayvon Martin shooting wouldn't have led to the same controversies if a white man had been shot. Perfectly plausible statement that an administrative agency concluded would be hostile environment harassment based on race. A photograph of an American flag burning in Iran. This is in the context of the Iran hostage crisis in the late 1970s. That was found to be potentially hostile environment harassment. Display of the Gadsden flag, the Don't Tread on Me flag, was found to be potentially racial harassment. There was no final decision, but it was remanded to the agency for further decision-making on the theory that it could be harassment because some white supremacist groups apparently use this very historic American symbol. So we might ask, well, what about debates about same-sex marriage, gender identity and discrimination rules, illegal immigration, immigration from various Muslim countries, how the law should treat Scientologists? Could that be hostile environment harassment? And I think it could be. All right, let me just close with 2 things. First of all, a Texas AG opinion, quote, just because, this is law, and law is the only discipline in which the phrase "that's an original idea" is a pejorative. So it's really important to always give authority, and here's authority. Texas AG has recognized that the model rule 8.4G, that's the ABA version, is likely unconstitutional. I actually neglected to add that just a few months ago, after I prepared this, the slides were borrowed from an earlier slide deck of mine. Pennsylvania, Federal District Court in Pennsylvania concluded the same thing about the Pennsylvania version of the rule. That's now an appeal to the Third Circuit. And the last thing I want to mention is what socioeconomic status. That's one of those things that's not like the other ones, right? The other ones already, there's prohibitions on employment discrimination and such based on race, sex, religion, etc. But this includes socioeconomic status. So let's say, for example, you're deciding whom to partner up with. And the person that you're thinking about, you ultimately conclude, this person doesn't have the kind of income that, or the kind of assets that I'd like to see in a partner. We might have some rough patches, and I want to make sure they've got a good buffer. Or alternatively, you say, actually, I want to go with this person who is a little bit less rich, because they're hungrier. They're more likely to really hustle for things. Or education. You're looking for lawyers from elite schools. That's a socioeconomic matter, and not for lawyers or paralegals or secretaries from less elite schools or vice versa. Well, all of that is potentially prohibited by this prohibition on discrimination based on socioeconomic status. Now, remember, I told you it's defined as unjust or prejudicial treatment. So I suppose the bar could say, well, there's nothing unjust about making this kind of decision. But how do we know? Why isn't it unjust? After all, they included socioeconomic status right up there together with all the other factors. So this is just another example here. That's not a constitutional objection, but I think another example of how kind of this attempt to sort of maximize anti-discrimination law, maximize anti-discrimination categories, shift everything to a more egalitarian mode, I think is a mistake. Certainly as to socioeconomic status, and is, I think, unconstitutional as to the harassment, at least as to certain kinds of speech. So with that, I close. Turn things over.
Thanks, Professor Volokh. And Casey, why don't you pick it up from here?
Good deal. And I will do my absolute best not to repeat just about everything that Professor Volokh said and try to actually add on. So I'll probably take a little bit less time, and then we can hopefully move to some questions. I'll begin first by saying, Miles, that you sort of set me up for failure in front of the South Carolina audience with talking about my Alabama background. I hope that no one holds that against me. That if 8.4 passes, I could be in real trouble with South Carolina attorneys wanting to go after me. So maybe Alabama attorneys could be a protected class in South Carolina. Maybe that's the answer here. I think Professor Volokh has set this up very well. Kind of what the real problems with this, and frankly, I'm just going to sort of add on a few examples of the ways that the imprecision in the wording here can be particularly problematic. I come from a background where I've litigated a lot of campus free speech cases. I think I've probably sued universities in about 30 different states, and so we see. Frankly, a lot of these exact issues, or a lot of the problems that persist with 8.4 come up in the campus litigation context. The thing that's really interesting to me with this rule is that it goes out of the way to try to disclaim the idea that, well, the law of harassment, as Professor Volokh pointed out, the law of harassment will guide our enforcement. That would have a lot more credibility to me if the rule itself made any sort of effort to reflect the law of harassment in the actual text of the rule, which it doesn't do, which causes me to wonder just how serious that promise is. So, one example of that is that, we do have a Supreme Court decision in Davis versus Monroe County School District that defines what harassment is for purposes of Title IX. And that's set out by the Supreme Court. It needs to be unwelcome, severe, pervasive, objectively offensive, interferes with someone's ability to get an education. Obviously, the educational component, doesn't work in this context. but the severity, pervasiveness, objective offensiveness provisions all would, and you don't see that reflected here. The way that actually plays out in the university context, universities are well aware of this. They know what Davis said. They have general counsel who are paid to read those opinions. They know what the case law says, and universities typically create speech codes that don't tend to follow the language, despite having clear instruction from the Supreme Court about what's actually required of them. And in the secondary school situation as well. So I'll just give you an example kind of locally of the way this kind of plays out, and maybe the the foreshadowing of what you might be able to expect in South Carolina if this rule became the law. And that's the decision in Abbott versus Bastidas, or the case in Abbott versus Bastidas, which is the University of South Carolina case that ultimately the students who were challenging University of South Carolina policy lost on standing grounds, but in a way that frankly should concern every attorney if you imagine this rule applying to you. Basically, the background on that case, and this is common of these campus free speech debates in a lot of different ways. The background on this case is that YAL students, Young Americans for Liberty students at the University of South Carolina, wanted to do a free speech event. And they thought the best way that they could raise concern on their campus about threats to freedom of expression would be to talk about the problems with free expression that had happened on other campuses. So they went to FIRE's database, Foundation for Individual Rights and Education. They went to their database and pulled a number of those examples and basically made giant posters of them and put together an event on their campus to show people these are the sorts of threats to free speech that are happening in other places. The response to that is, so they actually then showed University of South Carolina officials who said, yes, free speech is good, that's fine, go do your thing. So they go to do their thing, and of course that ends up leading to a complaint from someone else who sees the event and was offended by the event. Because some of the, one particular display had been a story that had happened at, I believe it was George Washington University, where a Jewish professor had actually returned from a trip abroad and had a swastika, which was a Hindu symbol, but he was basically using it for his class to demonstrate the way that symbols are misunderstood in different cultures, and you have to have the context to be able to understand the meaning of the symbol. So he shows that symbol at his George Washington University class. Others complain to the George Washington administration because of him, and so he has to go through a whole fight there. Now you have University of South Carolina students talking about that confusing free speech controversy that had happened on another campus. They are put through a couple week-long investigation to determine whether or not they should be punished for their speech. Everyone agreed that the University of South Carolina policies should not have actually led to any kind of punishment of these students, but they still had to go through several weeks of an investigation to make that determination. In the best case scenario, frankly, that's what I think would be the future under one of these rules, is that even if the people in the bar who are the ones who are interpreting these rules decide that what you said in that context was not, didn't have the requisite mens rea. It was not intended to be offensive. It didn't, even if they made those determinations, you can fully expect that there will be bar complaints filed in similar sorts of circumstances where it's tangentially possible that you could be accused, and then you'll have to deal with defending yourself in a bar complaint. And I could give scores of examples, similar situations in the university context where we've seen that play out, and it becomes almost sort of a tool that's used against people. And at the same time, you have universities who supposedly understand their First Amendment obligations, and yet they begin with something like, the harassment or discrimination. On the top level, everyone I'm sure on this call would agree, harassment, discrimination are both bad. The problem is when you take the definition of harassment and you extend it, as a lot of government actors would like to a multi-page long definition of harassment that by the end of it bears little meaning to the actual problem you set out to try to solve. And it seems like that's basically where we're headed with these proposals. I will also just point out before I move on from this point that for those of you on the call, South Carolina is well behind other states in actually setting out some sort of, in the campus context, well behind other states and actually adopting some sort of state legislation that deals with the speech code provisions and things like that. So again, doesn't give me a whole lot of hope that we can expect this language from the South Carolina bar to be narrowly confined when South Carolina continues to not be in a good place even with its universities and trying to carefully define this kind of language. I think at the end of the day, anyone who advocates for speech restrictions needs to ask whether you want that tool in the hands of the people that you most disagree with. I think this rule has laudable and understandable goals, but it ultimately ends up being a very bad idea because it fails on that very basic point. It's unlikely to result in anything other than these sort of, broad attacks on people that you disagree with, and sort of dragging people into bar complaints that, while they may not ultimately succeed, end up succeeding because of the fact that they can make things difficult for people who have views that are outside the mainstream, or at least views that some might view as controversial. I think we've talked through 8.4, the South Carolina version. On the broader Rule 8.4G conversation, I think the South Carolina, I don't know if Eugene will agree with this or not, but it seems to largely take off the table, at least it hopefully takes off the table. I need to think through this a little more carefully. The possibility that merely declining representation of someone is itself going to lead you to punishment. I think that's one of the real problems with the ABA model rule, is that it seems to me it goes exactly the wrong direction. We should want attorneys to try to have as much candor with their clients as they possibly can, and to be as humble as you can about your own biases and your own ability to zealously advocate for someone. So with the Rule 8.4 from the ABA, it sort of sets it up where unless you think that it's going to not be possible for you to provide a representation for someone, that you should go forward with the representation. If I was someone who had a cause that I wanted represented, and I found out that my attorney was withholding from me the fact that strongly disagreed with my position, but they're withholding that information and not sending me to another attorney because they thought that the rules of professional conduct required them to go forward with the representation so long as they thought they could continue to do a good job. I'd rather them tell me that up front. Tell me that if you were sort of having a war within your own mind through my entire representation, let me know that so that I can make a determination to go find someone who is going to be not have that sort of internal battle over representing me. So I'll stop there and see what questions we have, but I'm curious if Eugene agrees on that point about the South Carolina rule and whether it sort of addresses that sufficiently.
Before you respond to that, let me just remind our attendees we're at the halfway point. So if you can do the check-in and the Q&A, just give us your name so we can confirm you're still attending. And then I'll remind you once more at the end. But go ahead and fill this in. Professor Volokh, I'll let you respond to Casey's question. I think you're on mute right now.
Yeah. So first, let me just observe one very important thing that Mr. Mattox mentioned. By the way, can we be on a first name basis? I'm Eugene.
Casey. Yeah, there you go. Yeah.
All right. Good. So one point that Casey mentioned can be summarized as the process is the punishment. And certainly no lawyer wants to be even the target of a disciplinary proceeding. The expense of dealing with it, the risk if something were to happen, the possible reputational damage if some discipline is announced. It's a huge deterrent effect for people. As to this question of how this would affect interactions with clients in situations where the lawyer sharply disagrees with the client, it's an interesting issue. So let's say, for example, as I understand Casey's concern is, imagine that some church comes to you and asks, can you represent us in this property dispute, or even this dispute about protests outside of our church, or something else, something very ideological. You're allowed to say, I'm not interested, even if the real reason is you don't like this church. But it is potentially dangerous to say, look, I'm happy to represent you and I'll do the best job, but I just want you to know, I actually think your church, your ideology is a bad ideology. Maybe it's heretical ideology, if that's the way I think through things. It's not going to stop me from doing a good job for you, among other things, because I believe in your legal theory. I really do believe that you are entitled to this kind of protection. But it's going to come out. You're going to hear, oh, didn't you, from some friend of yours, didn't you know that Volokh actually thinks that we're all a bunch of evil heretics? I don't want that to blindside you. So let me just tell you up front. Yes, that does potentially raise the danger that the bar will say, oh, had you just said no, then you'd be fine. Had you just said yes, you'd be fine. But when you said yes, but before deciding, please consider this, that might be harassment. Now, to be fair to the proposal, the harassment does require a pattern of intentional, substantial, and unreasonable intrusion into the professional life of a targeted person or group that serves no legitimate purpose. And the most objective of those is pattern. The word pattern is actually borrowed in some measure from some criminal harassment laws. I said this isn't about those primarily, but there is a lot of criminal harassment laws do involve a pattern of conduct. Generally requires 2 or more incidents. So it may be that you'd be off the hook by just saying, look, it only happened once. Of course, you'd also say it wasn't unreasonable, it wasn't into their private or professional life, it served a legitimate purpose, it wouldn't cause mental or emotional distress, but those are all quite vague. Pattern and maybe a little less so. So I think that's probably not going to be a problem, but I can't be sure. And again, people might figure, as between that risk and simply saying no, and in fact denying the client the opportunity to have a fully to have a good legal advice and fully informed about your personal tension with the client's beliefs, that's the safe path. Whereas explaining things to the client is a dangerous path. So I think that's a very serious issue to consider, although to me not the primary one, in part because I do think that this pattern element, it ought to be enough to protect against that.
Well, we've got about 20 minutes left, and we have an embarrassment of riches of great questions that folks have been sending in. I'll try to get through as many as I can. I also apologize if we don't get to your question, either due to time or, and this is maybe a self-inflicted wound on my part, a lot of the questions are in the Q&A box, which is now also populated with people's names and bar numbers. But I'll scroll back and try to catch as many of them as I can. Why don't we start picking up on the topic that y'all were just talking about, the exception in the rule that allows a lawyer or a law firm, I'm not sure, that's part of the question, to limit their practice to a particular type of clients. So I guess the first question that I got on that, which I'll ask first, and I think there will be some follow-ups, does that exception apply just to an individual lawyer, whether a solo practitioner or an individual lawyer within a firm, or does it allow an entire firm to either limit its practice to a particular type of client or conversely to exclude a particular type of clients?
I don't see anything here that actually bars firms or governs firms. One question is the managing partner of a firm might be faulted for having this policy for the whole firm. But I think subsection 8 should provide immunity for the partner in that kind of situation. I think the classic example of that is there are some family law firms that specialize in wives and some in husbands, and some do both. I think this is a lot less common, the specialty less common now than it once was. But But I think age should be broad enough to protect a firm-wide decision along those lines. Again, it would be a rare firm that would have that, in part because family law firms tend to be relatively small, certainly a rare large firm that would have that.
I'll add that, you know, the thing that this reminds me of, I mean, on that, the idea of limiting your practice to particular types of clients, similar sorts of supposed exceptions or to some degree objections to conscience clients have been around, you know, for decades now. And you know, so it usually comes up in the context that, well, look, if you know, if you didn't want to assist in abortions, you shouldn't have become a labor and delivery nurse. If you pick your issue, right? Whatever the you know, issue of the moment is. If we're, you know, so there, I mean, there is some logic to the idea that, you know, look, if you want to protect yourself, just don't decide to do hot button culture war cases or something. Although that would probably be exactly the problem here. But you know, you could sort of, to some degree, one could say, well, these are the types of issues that I don't want to try to take on, so maybe we're not doing family law or something like that. The challenge with that is that, you know, as the issues that are the hot button issues seem to touch more and more aspects of life all the time, and it makes it much more difficult to try to anticipate decades in advance what are going to be the issues, right? There was a time when someone might have thought, you know, look, I want to stay out of the culture war fights that are roiling this country, so I'm just going to spend my time opening up a bakery. I'm going to decide that I'm going to, you know, to just become a florist and sell people flowers, and that'll be the way that I will avoid the culture war fights that are sort of affecting the rest of society. That didn't work well, right? You know, as things change, then, you know, you find your tax practice suddenly directly in the middle of questions about same-sex marriage that you wouldn't have anticipated at one point in time. So I don't know that it's a complete answer to just say, well, just, you know, order your practice in such a way that these issues don't come up. You know, I think that's, it may come up less, but you're basically going to have to deal with some of these questions. If you have areas where you would not want to engage, you're going to have to deal with these questions one way or the other.
Let me ask a follow-up to that on the question of this particular exception. I'm thinking of an example, right? So when I was clerking, my judge mediated a dispute where one of the parties, a group of parties, were a group of Native American tribes. They are represented by a public interest firm called the Native American Rights Fund, NARF. The only thing that group does is represent Native American tribes and bands, not musical bands, but bands of people, obviously, typically in lawsuits against the federal government relating to settlement funds and the alleged mismanagement thereof. But I think we can all agree that we look at that example does not strike us as being some sort of invidious discrimination against all others. We could also, though, think of, and I'm hypothesizing here, an example where, let's say you had a lawyer who was in fact a bigot, a racist and a bigot, who said, I will not represent any person of any names or race. And I think we would all agree that's morally offensive and unjust. Does this exception to the rule, allowing lawyers or firms to limit their practice to particular types, does it allow for the one that seems to us perhaps good and just, and does it prohibit the other, or does it outlaw them both? Does it allow for them both? How does it affect racial prohibitions or limitations on client representation?
You know, it seems to me that the answer is it allows them both, right? 8, declining representation is not regulated by paragraph H. That's just that. If somebody says, you know, I don't want to serve blacks, or I don't want to serve whites, or I'm a Palestinian activist, I don't want to serve Jews or Israelis in particular, or vice versa, you know, you could say it's just or unjust, but you don't even get to the question, which is itself, by the way, part of the definition of discrimination, what's unjust treatment, because hate does indeed allow that. And I think that's good. I do think that in a decision that's sort of as personal as, are you going to put your mental efforts behind crafting an argument in favor of a particular client, you should have very broad authority about deciding just not to do it. So I don't think, I mean, by the terms of the rule, I just don't think either of those kinds of examples are covered.
Okay, a couple that I think we can probably knock out with relatively quickly. The question was the reason that there is a First Amendment aspect to this at all is because the rules are being adopted by a state Supreme Court and promulgated and enforced by the state's Office of Disciplinary Counsel, as opposed to, for example, the NFL, who can tell players they can or can't kneel or stand or raise a fist or that sort of thing. That's the First Amendment implication, right? Is because of the source of the rule.
That's right, and you know the fact that you've got to basically submit yourself to those rules in order to practice law in the state of South Carolina, right?
Which leads me to the next.
Right. Although I'm sorry, I want to add, not that it's directly relevant to this to 8.4, but it is relevant to the question. South Carolina is one of about half states that ban private employers from discriminating against employees based on certain kinds of speech or political activity. The South Carolina statute says it's unlawful to discharge a citizen from employment because of political opinions or the exercise of political rights and privileges guaranteed to every citizen by the Constitution and laws of the U.S. or of the state of South Carolina. So the exact scope of this may not be completely clear. There's not a lot of case law on this. By the way, this is based on a statute first enacted in 1868. These kinds of bans on political discrimination. And before that, discrimination based on voting, back when the vote was public rather than secret, are among the earliest employment anti-discrimination laws in the country. In fact, those two are the earliest, long before there were bans on discrimination based on race, religion, sex, and the like. If a law firm were to say, we're going to punish you because you express political opinions or exercise political rights, which may include First Amendment rights to speak on a wide range of topics, that might very well violate South Carolina law.
So I really, really like the fact that you brought that up. And we don't have time to talk a lot about that today, but maybe we can do another panel just like this in, I don't know, a couple of months, because I would love to talk more about that statute and how, how it interacts with, for example, Hosanna Tabor and the ministerial exception. What happens if a religious employer releases the person? Well, now we've got this state statute, but... Right.
Or what happens if a newspaper says, we will not allow our reporters to participate in politics because that undermines their credibility as impartial journalists. That very issue came up in Washington State under that statute, and the court split 5-4 on the issue, and I won't tell you which decision it reached. So leave it as a cliffhanger for that next panel.
That's right. We'll be here again in a few months, and we invite you all back to find out what happened. Let me circle back. Casey, right, you ended your comment a second ago by saying, right, the reason there's a First Amendment implication here is because it's coming from a state entity, and you have to be a member. You have to comply to engage in this livelihood. Okay. Would it be different? South Carolina has a mandatory bar, right? I and everybody else who practices law has to be a member. Would it be a different animal entirely if South Carolina was not a mandatory bar?
I think it would. At least it would alleviate some of the some of the problem. I think you still have a question of a state entity being the state Supreme Court issuing these rules. So I think that would still be problematic. But I think you could basically avoid their import if you were not forced to comply, right? So. I don't know. I mean, I know there are a few states, Eugene. I'm curious as to your thoughts on that question, because there are a few states that, that don't have a mandatory bar, and I'm wondering how this applies in that context.
Well, if it weren't a mandatory bar, then I don't think the state Supreme Court would be involved in this. My sense is that there are states that have bar associations that are like the American Bar Association, right? They are private entities, and they can, generally speaking, set up their own rules. I do think that especially important professional entities should not, and especially ones that seek to be seen as nonpartisan, should not have rules that exclude people based on their speech as a general matter. But that's more a matter, I think, of professional ethics and what I think is good for society. It's not a matter of law. So yes, if it were a purely voluntary bar, which just happened to put on interesting events, where it would be like the Federalist Society, not that we do exclude people based on their viewpoints or their speech, but if we did, that's not a big deal, in a way that it is a big deal if it's a government-run entity, especially a mandatory.
Something that we've seen in the last couple of years, or I guess probably more, I don't know how long, something that I have noticed, maybe it's been going on longer than that, but that I have become more aware of in the past few years, is seeing people weaponize the rules of professional conduct and state disciplinary offices against elected officials. So let's say you don't like the fact that Ted Cruz went on vacation during a snowstorm. Right, he's a lawyer, he's a member of the Bar of Texas. Somebody could file an ethics complaint against him, I don't know, alleging what.
Right.
If Rule 8.4 is in place, how does that overlap with, let's say, an elected official's votes on particular issues, right? How somebody votes on the Equality Act, or how they campaign and talk about it. Does that expose officials to perhaps more plausible sounding ethics complaints?
There's nothing in here that would exclude that. In fact, it says, based on the totality of the circumstances, including whether the conduct was committed in connection with the lawyer's professional activities. Now, a lawyer who's in the legislature may use the lawyer's legal experience as part of the legislative work, but that's not the lawyer's professional activities. Still, the rule would apply beyond that. Now, I suppose the legislator could say, well, wait a minute. What I did serves a legitimate purpose. I'm representing my constituents. I think I would be perfectly willing to be eager to litigate that case on behalf of the elected official. This having been said, this is something that could end up being used against the elected official, and precisely just to create bad publicity. Oh, this person might be disbarred for his vote, on the theory that his legislative agenda is an unreasonable intrusion into the professional or personal life of some group that serves no legitimate purpose. And you're right that it could become a political weapon, precisely because it's not limited to professional activities. In this respect, by the way, it's even broader than the proposed ABA rule. It's in some ways narrower, but at least the proposed ABA rule says it's with regard to professional activities. Now, that includes social activities connected with the practice of law. That includes CLE programs and the like. That includes bar association activities. So already the ABA rule is too broad. But this is even broader, because whether it's committed in connection with the lawyer's professional activities is just a factor, just one of the totality of the circumstances. So I totally agree that this is something that potentially is very dangerous.
Yeah, I agree. This would basically just get you back to the point we were discussing earlier, right? It's the process is the punishment. So there are I think if you are a solo practitioner somewhere, you have fewer people who are going to be looking for an opportunity to try to weaponize something like this against you. As you move up and you're a larger firm attorney, or you are sort of more, you've got a larger group of clients, you're obviously going to increase that risk from people who don't like you, don't like your clients, don't like something that you've said or done. And frankly, once you become governor of the state or senator, then there's 46% of the population at any given time that would love the opportunity to be able to have a press release that demonstrates that what you advocate for is terrible and awful and bad. This is a hook to do that.
We've got a few minutes left. I'm going to try to hustle through. And again, I apologize to folks whose questions I either have missed in the shuffle or we run out of time for. One of the questions that was in the Q&A said, 20 states have adopted this rule. What types of investigations have resulted there? I guess first, the premise of the question, the 20 states have adopted that, I was unaware of. Do you know if that's correct?
That's not right. I think maybe 2 states. One of the New England states, I want to say Vermont, and maybe one other state have adopted it. Pennsylvania adopted it, which is why it was struck down in Pennsylvania. So maybe it's just those 2. Now, it's true that many states have adopted a version of the rule that bans certain kinds of conduct, including harassment, in the course of the administration of justice. So that is, for example, if you are engaging in this conduct towards a witness, towards opposing counsel, towards court personnel, possibly even towards your own client. And the theory there is it's prejudicial to the administration of justice because it interferes with the conduct of a case. And we do know that the free speech rights of lawyers in the course of the conduct of a case, certainly in the courtroom, but also outside it, are more limited. You could get sanctioned if you file a brief in which you say really rude things about opposing counsel, or really rude things about court personnel. I've seen such cases, and generally speaking, that's seen as permissible because it is a regulation not just of lawyers writ large, but regulations of the conduct of a particular case that interferes with a just result in that case. But if you write an op-ed sharply criticizing some lawyer, not your opposing counsel in a case, but just in general, or sharply criticizing some judge, that's fully protected speech. Likewise, if you say things that are seen as harassment based on race, religion, or sexual orientation in a CLE event, that's also fully protected speech. So those 20 states have a much narrower version of this rule, and one limited to the area, the administration of justice in the course of litigation of a case, the area that indeed the government has more power, the bar has more power to control.
Let me take a second. We're almost at the conclusion of our time together. So for those of you watching or listening on the phone, this is your last checkpoint to drop your name in the Q&A box or to send me an email just to confirm that you're still with us. We'll compile all those. We'll submit it to the commission on CLE. We've got about one minute left. So let me toss out a last question, and if you, I will preemptively allow you to exceed the time allotted if your answer takes more than a minute, and if you're able to stick with us a little bit longer. The question is this: South Carolina has a Religious Freedom Act. It's like a state RFRA, which, like the federal RFRA, applies to all of South Carolina law. The SCRFA doesn't appear to be implicated by the proposed rule's free speech carve-out. Does this again mean that the rule privileges statutory rights over state and federal rights to free speech?
Can I give that to Casey?
Yeah, I was going to say, I'm not sure, Eugene, if this has come up in other states where you've looked at this. I mean, basically without having the South Carolina RFRA in front of me, I assume if it applies the same way that the federal RFRA does, which is to say that, you know, on the federal level, RFRA applies unless it says it expressly doesn't, then the sort of the carve-out point, that may not be relevant, right? Like you could basically still raise a RFRA defense potentially to a claim here. But I think what that speaks to then is, you know, the need to deal with that up front and not leave people in the position of having to argue before a disciplinary committee of the South Carolina Bar making a RFRA defense. Instead, the people who would want to come up with a rule like this need to actually struggle through and figure out, well, you know, what language is appropriate in South Carolina, given the availability of such a defense, so that you're not sort of forced through the process in order to hopefully vindicate your interest on the other side.
Yeah, so that all sounds exactly right, but I want to add one more thing. some states have taken the view that under the state separation of powers doctrine, the conduct of litigation and of the bar are a matter solely for the judiciary and not subject to legislative control. To the point that they have struck down state codes of evidence that are enacted by the legislature on the theory that, evidence rules are about what happens in court, and that's for the judiciary. I do not know where South Carolina stands on that, but it's conceivable the South Carolina Supreme Court might say, look, the legislature cannot control either the proceedings of our courts or our power to regulate the bar, especially if the South Carolina Constitution, like some constitutions, but I'm not sure about the South Carolina one, specifically provide that the Supreme Court shall be a regulator of the bar. So this is one interesting question. I think as a practical matter, it'll pretty rarely come up. There are fairly few religious objections. There will be fairly few religious objections to this particular rule that aren't also free speech objections. One exception, one kind of objection might be my religion precludes me from representing these kinds of clients, but that's already carved out from the rule. But it's an interesting question of state separation of powers, among other things.
All right, well, we're a few minutes past. I appreciate you all sticking with us a bit. And again, thank you so much, Casey and Gene, for joining us. This was incredibly interesting, at least if you're a free speech nerd, as I admit to being. And I think even for those who aren't, found it interesting and educational and informative. So we thank you for your time. And I'll be in touch about setting up that next webinar about the
You got it.
carve-out statute you talked about. All right, thanks, y'all.
Great. Such a pleasure, always.